Hello everybody. In this session we will be discussing on how to approach the Indian polity from mains perspective. So before you start, we need to be aware about the syllabus. In GS2, as per the syllabus, we have 9 topics that is dealing with Indian polity. So in this session we will be discussing on each topic and the questions that have come associated with that particular topic. So first of all, we will begin with the first topic, that is Indian Constitution, historical underpinnings, evolution, features, amendments, significant provisions and basic structure. So this is the first topic. Now when you analyze the questions that have been asked, we have in 2016 about 5 questions being asked from this section. So about 5 questions have been asked from this section. So we will go by question wise. First the question, if you look into the first question, it is discuss the essentials of the 69th Constitutional Amendment Act and anomalies, if any, that have led to the recent reported conflicts between the elected representatives and the institution of Lieutenant Governor in the administration of Delhi. So this particular issue was current affairs during 2016. So since it was in current affairs, the UPSC wants you to have an idea about what the issue is all about, and that is why the question has been about the 69th Constitutional Amendment Act and its anomalies. So and that the basic reason is being asked in here. Now then again the question have been, do you think this will give rise to a new trend in the functioning of the Indian federal politics? So not only has the issue been asked, but also its implications have been asked. So this kind of perspective is very important, and when you look into what topic in the syllabus we can associate this particular question is the amendments given in the Indian Constitution topic. So that is regarding the first question, that is regarding the 69th Constitutional Amendment Act. So any amendment act in news, you need to have an idea about what the issue is all about and also the implications. Now another example is the second question. We'll go through it. Now to what extent is Article 370 of the Indian Constitution bearing marginal note temporary provision with respect to the state of J&K temporary? So that is the question asked, to what extent it is temporary. Discuss the future prospects of this provision in the context of the Indian polity. Again, if you look here, again the implication is asked. The 370 article is asked how it is temporary. All about this article 370 is asked, and its implication has also been, future prospects has also been asked. So if you associate this particular question with the topic in the syllabus, it is significant provision. Such a provision is in current affairs in 2017, that is with respect to the article 35A. So that is important from the mains perspective. Now we move on to the third question. So the third question is, discuss each adjective that is attached to the word republic in the preamble. So, and second thing is that, are they defendable in the present circumstances? So what is asked here is that the adjectives that are associated with the preamble, the adjectives that were associated with the word republic was in news during 2016, and its relevance was also debated. So you can say that this third question is purely a current affairs question. Now you can link this particular topic with the features of the Indian Constitution, that is again given in your syllabus. Then look at the fourth question. What was held in the Kolo case? In this context, can you say that the judicial review is of key importance among the basic features of the Constitution? So once again, what was held in the Kolo case? So that is a landmark judgment with respect to the judiciary as well as its interpretation. And in this context, can you say that the judicial review is of key importance among the basic features of the Constitution? So judicial review and basic feature, its link is being asked, and this you can say that it is from conventional area. That is, you are expected to know about certain landmark judgments like Kolo case, you have Keshavananda Bharati case. These cases are always landmark judgments and you have to be aware about what the case was all about. The fifth question is, did the Government of India Act of 1935 lay down a federal constitution? Discuss. So this is a question. So it's all about Government of India Act of 1935. So when you analyze this, it comes under the historical underpinnings. That is, this 1935 is one among the historical underpinnings. So this is also you can classify it under the conventional areas. So that is the fifth question. Now look at the sixth question. Discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided for in the Directive Principles of State Policy. So that is also, it is asking about the Article 44 of the DPSP. The Uniform Civil Code have been in use for a long years. So this was one of the current, you can link it, you can classify this particular question under the topic of current affairs. So the seventh question, so we look into the seventh question. Starting from inventing the basic structure doctrine, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy. So that is a statement. In the light of the statement, evaluate the role played by the judicial activism in achieving the ideals of the democracy. So this you can link it to the basic structure portion that is given in your syllabus, and also with respect to the evolution, because it's when the judicial review or the judicial activism that have over the years led to the evolution of the Indian Constitution. So these are the sections, so these are the questions that are being asked from the section of Indian Constitution, historical underpinnings, evolution, features, amendments, significant provisions as well as basic structure. So you have 5 questions being asked in 2016. Few are current affairs as well as few are basics. So one has to know both the basics as well as and be very sure about the current affairs topics also. Now next is, that is the next section is functions and responsibilities of the union and the states, issues and challenges pertaining to the federal structure, devolution of powers and finances up to the local levels and challenges therein. So that is the next section. Now this is a dynamic area because you have the state and the center as well as the state relation changing over the years. So we look into the first question. The concept of cooperative federalism has been increasingly emphasized in the recent years. Highlight the drawbacks in the existing structure and the extent to which the cooperative federalism would address the shortcomings. So when you look at the cooperative federalism, the concept, it has been in use for few years, that is 2 to 3 years, and it is actually becoming a new phase of Indian federalism. So this is related to current affairs, that is the concept of cooperative federalism is related to current affairs, and it is telling what is a good thing about cooperative federalism. That's why it is asked, highlight the drawbacks and the extent to which this cooperative federalism would answer the shortcomings. So you need to know about the shortcomings of the existing structure as well as your suggestions can also, and analyze the cooperative federalism and also give your suggestions. So this is with respect to the first question that was asked in 2015, and that was the time when the cooperative federalism was highly in use. So the second question, in the absence of a well-educated and organized local level government system, panchayats and samitis have remained mainly political institutions and not effective instruments of governance. The question is to critically discuss the matter. Now this question, this can be linked to the devolution of the powers to the local levels, and this was asked during the 2015 because of the issues that was happening in states like Haryana as well as Rajasthan, where certain changes were being brought in with respect to the educational qualifications of the people who are standing for as candidates in the grassroots level. This was a current affairs, but then again you have to be aware of the various shortcomings that the samitis as well as panchayats are facing now. So that is the second question. So that was asked in 2015. Now the third question is, though the federal principle is dominant in our constitution and that principle is one of its basic features, but it is equally true that the federalism under the Indian constitution leans in favor of a strong center, a feature that militates against the concept of a strong federalism. Discuss. So looking at the question, it is mainly with respect to the relation between the center as well as the states, and this particular topic can be linked to the challenges that is pertaining to the federal structure. So this was asked in 2014, and it was after that those years that the cooperative federalism came in, and that brought in a new phase in the Indian federalism. So that is the third question all about. Now we move on to the fourth question. The question goes, recent directives of the Ministry of the Petroleum and the Natural Gas are perceived by the Nagas as a threat to override the exceptional status that is enjoyed by the state. Discuss in light with Article 371A of the Indian Constitution. Now this particular section, that is Article 371, can be linked to the topic of significant provisions in the Indian Constitution. But why it is given more importance under this particular topic is that it is one of the challenges or issues wherein the center is intruding or encroaching on a power that is given, that is the exceptional power or a special power that is given to the Nagaland with respect to its petroleum as well as natural gas. So that is, this was in current affairs at the time 2013 when it was asked. So that is one of the reasons why this particular question came, and it was also related to the challenges relating to the federal structure. So that is the fourth question. And you have the fifth question. Many state governments further bifurcate the geographical administrative areas like the districts and the talukas for better governance. So that is a statement. In light of the above, can it also be justified that more number of smaller states would bring in effective governance at the state level? So this was because of the current affairs again, because of the issue of Telangana, the announcement or the decision by the center to form a separate state of Telangana. So the state formation, it pros as well as cons you need to be aware about, and here it is asked about the justification of having more states. So that is with respect to the fifth topic or the fifth question. Now, so when you analyze, you can see that most often it is a current affairs that is asked from this section. But again, you have to be aware of the basics, like what is happening in the with respect to the devolution to the lower levels of the country or the grassroots levels of the country. So you need to be aware about the basics also. Now we move on to the third section, in which it's written the separation of the powers between the various organs, dispute redressal mechanism, and the institutions. So separation of powers between the various organs means we have the problem that is coming between the judiciary as well as the government or the legislature. So the first question will give you an example what exactly it's meant by this particular topic. The first question under this particular section goes as, resorting to ordinances has always raised concern on violation of the spirit of the separation of powers doctrine. While noting the rationales justifying the power to promulgate ordinances, analyze whether the decisions of the Supreme Court on the issue have further facilitated resorting to this power, should the power to promulgate ordinances be repealed. So this is again a current affairs, and ordinance is one of the issues that have always affected or brought in the debate of separation of powers between the judiciary as well as the executive. So that is what exactly is being asked in here. So what you have to justify the ordinance, and then you have to analyze it with respect to the Supreme Court verdict, as well as whether you have to tell your opinion whether this promulgation should be repealed. So that is the first question. So the next question, second question goes, what are the major changes brought in the Arbitration and Conciliation Act of 1996 through the recent ordinance promulgated by the President? Now, how far will it improve India's dispute resolution mechanism, and discuss. So this is correctly linked to the dispute redressal mechanism, and with respect to the Arbitration and Conciliation Act of 1996, that was in news during 2015. So that is the reason why a question was being asked from the section. Third question, the Supreme Court of India keeps a check on the arbitrary powers of the Parliament in amending the Constitution. So that again is a separation of from the separation of power section. So when you look into it, you can say that from this section or from this particular topic, most often it's a current affairs that is being used. So that is the main aspect. So the fourth section is comparison of the Indian constitutional scheme with that of the other countries. No questions have been asked since the syllabus has changed. So we will move on to the next topic, that is the fifth one, Parliament and state legislatures. Structure, functioning, conduct of business, power and privileges and issues arising out of it. So this is the section all about, that is Parliament and state legislature, its functioning as well as its various aspects like the privileges and the issues arising out of it. Now when you analyze a question, the powers, the first question, the powers, privileges and immunities of the Parliament and its members as envisaged in Article 105 of the Constitution leave room for a large number of uncodified and unenumerated privileges to continue. Assess the reasons for the absence of the legal codification of the parliamentary privileges, how this can be addressed. So this is a question. So you can directly link it to the privileges, power and the privileges that is mentioned in the syllabus itself. Now this particular section or this particular question was being asked because it was in the current affairs, and in 2017 also it has been in current affairs due to the issue that has occurred in Karnataka Assembly. So in that respect, please do look into the privileges. And then the second top question that has been asked is, the role of the individual MPs or the members of the parliament has diminished over the years, and as a result a healthy constructive debates on the policy issues are not usually witnessed. How far can this be attributed to the anti-defection law which was legislated but with a different intention? So this is mainly dealing with the functioning of and the conduct of the business of the parliament as well as the state legislature. So you have to look into it, that is what is exactly the functioning or the conduct of the business of parliament, and analyze it, and one of the reasons for its not functioning is the anti-defection law, or one of the reasons that prevents a healthy debate is the anti-defection law, and so you need to be aware of this particular topic and what is exactly the problem in this particular act. Now the sixth section is all about the structure, organization, functioning of the executive and the judiciary, ministries, departments of the government, pressure groups and informal as well as informal association and their role in the polity. This is a wide topic, but we will go through the questions. First is, the Indian party system is passing through a phase of transition which looks to be full of contradictions and paradoxes. So now it is being asking about the legislature, now how its composition is all about, the Indian party system and its influence. So that is being asked, and that is with respect to the present government or present parliament. So that is linked to the current affairs. Second thing, Khap Panchayat have been in news for functioning as extra constitutional authorities, often delivering pronouncements amounting to human rights violations. Discuss critically the actions taken by the legislature, executive and the judiciary to set things right in this regard. So this was a time in 2015 when Khap Panchayat and the honor killing was happening and was in current news, was in news then. So this was in 2015 when the Khap Panchayat was highly in news. So not only has the Khap Panchayat about Khap Panchayat being used, and it is also asking about what the other organs or the formal organs of the state of the country has been doing in order to address the issues that is arising out of such informal associations. So that is, you can link the Khap Panchayat with the informal associations and their role in the polity. So that is the second question. Third is, does the right to clean environment entail legal regulations on burning crackers during Diwali? Discuss in light of Article 21 of the Indian Constitution and the judgments of the Apex Court in this regard. So this is obviously it is so this question is current affairs. It was with reference to the verdict that the Supreme Court had given. So similarly, in the present or in 2017, you can also draw similarity to the right to privacy being judged as a fundamental right. Now that's a potential question. The next, fourth question. Starting from inventing the basic structure doctrine, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy. In light of the statement, evaluate the role played by the judicial activism in achieving the ideals of the democracy. I have already mentioned about this particular question in the first section where I've related it to the section to the topic of basic structure. So the fourth as well as third, fourth is mainly referring to the judiciary and its functioning. Now judiciary and its functioning is also in news in 2017, so we have to be aware about the current affairs related to the judiciary also. Now next is the fifth question, that is instances of the President's delay in commuting death sentence have come under the public debate as a denial of justice. So this was in news. Should there be a time limit specified for the President to accept or reject such petitions? Analyze. So this was in news. Now this can be linked to the functioning of the executive. So this fifth question is in regard to the functioning of the executive and its delay in commuting the death sentence. So this was in news and that is why it was asked in 2014. Now the sixth question, the size of the cabinet should be as big as the government work justifies and as big as the Prime Minister can manage as a team. How far the efficacy of a government then is inversely related to the size of the cabinet? Discuss. So this is the sixth question. Now this particular question can be related to the topic of structure and organization of the executive. Now that the size of the cabinet and its functioning and its efficacy, that was in news as well as with the subsequent governments forming the cabinet. The seventh question is, pressure group politics is sometimes seen as an informal phase of the politics. With regard to the above, assess the structure and the functioning of the pressure groups in India. It is given in the topic itself about the pressure groups and their role in the polity. So that has been directly asked and it is basically a conventional area. So these are the questions that have been asked from the sixth section of the syllabus. So next we move on to the seventh topic, that is salient features of the RPA or the Representation of the People Act. No questions have been asked since 2013, but since the RPA is presently in news, you have to be aware about the issue of RPA, what are the amendments being sought by the Election Commission and etc. Now the eighth topic, appointment to the various constitutional posts, powers, functions and responsibilities of the various constitutional bodies. So this is in respect to the constitutional bodies, and when you analyze the first question, exercise of the CAG's, Comptroller and Auditor General's power in relation to the accounts of the Union and the states is derived from the Article 149 of the Indian Constitution. So that is given in the question. Discuss whether the audit of the government's policy implementation could amount to overstepping its own, that is CAG's own jurisdiction. So now it is discussing about the ambit of the CAG and its audit. So the CAG is an important constitutional body and a UPSC aspirant has to be aware about CAG, its functioning and what is the current affairs or what is the present status of the audit jurisdiction of a CAG. So this is a conventional as well as a current affairs. So one has because over the years, that is in 2014, 15, 16, you can see that the jurisdiction of the CAG is expanding as because of different developments. Now we move on to the second question. Constitutional mechanisms to resolve the interstate border disputes have failed to address and solve the problems. Is this failure due to the structural or process inadequacy or both? Discuss. So this has been because the interstate border disputes have been in news and the constitutional mechanism have been seen as a failure. That is why the interstate water disputes have remained unresolved. So the question again is it the failure? So you need to analyze the situation, what exactly the issue is all about. And in 2017 also we have seen that there are plans to subsume all the tribunals and make it a single tribunal. So this interstate water dispute tribunals is again in news. Now the third question is, discuss the recommendations of the 13th Finance Commission which have been a departure from the previous commissions for strengthening the local government finances. Now when you analyze the third question, it was asked in 2013. So it was the 13th Finance Commission that was in news. Now presently, so the Finance Commission is a constitutional body, so it can be related to the functions of the constitutional bodies as mentioned in the syllabus. And in 2017, you can see that Finance Commission is important because till now the 14th Finance Commission debates or the analysis is going on and the government has accepted the recommendation that is provided by the 14th Finance Commission, and then also there are plans to form the next that is the 15th Finance Commission for the year of 2020 to 2025. So Finance Commission is also important from this perspective. Along with it, if in 2017, which is the most important constitutional body that has been in news, is Election Commission. So one has to be aware about what all is happening with the Election Commission, what is the problem, what steps it has taken recently, and what steps it is seeking from the government, and what is the new things that is going to bring about, that is VVPAT, etc. So the ninth topic is statutory, regulatory and various quasi-judicial bodies. Now in this question, in this section, if you analyze the questions and its pattern, you can say that one question is sure from this particular topic, that is the ninth topic. You can see that in 2016, 15, 14, 13 you have question coming in. We look into the questions. Now what is a quasi-judicial body? Explained with the help of concrete example. So that is a question. Now this simply means you need to have an idea about the basics of the terms. That is the first question. Second thing is, for achieving the desired objectives, it is necessary to ensure that the regulatory institutions remain independent and autonomous, discussed in light of the experience in the recent past. Now this is because of the repeated criticism that there has been interference in the functioning of the regulatory bodies. So it's explicitly given in the syllabus also, regulatory bodies. So that is why the second question has been was asked in 2015. And then third question is, NHRC or the National Human Rights Commission in India can be most effective when its tasks are adequately supported by the other mechanisms that ensure the accountability of the government. In the light of the above observation, assess the role of the NHRC as an effective complement to the judiciary and other institutions in promoting and protecting the human rights standards. So NHRC is a statutory body. So from this question it is clear that one has to have an idea about certain important statutory bodies. So the fourth question, the product diversification in financial institutions and insurance companies resulting in the overlapping of the products and services strengthens the case for the merger of the two regulatory agencies, namely SEBI as well as IRDA, justify. The SEBI is a capital market regulator and IRDA is an insurance sector regulator. So this was asked because this case was in current affairs at that point in time, that is in 2003. This was being asked because this particular case between the SEBI as well as IRDA was in news in 2013. So similarly, we have the regulatory turf that is happening between regulators like SEBI and RBI. That is the first issue. Second thing is between the Competition Commission of India as well as Telecom Regulatory Authority of India. So these both are important. So the statutory, regulatory, quasi-judicial body. In quasi-judicial body, you have the latest move of merging of the tribunals. So that all are current affairs that can come underneath this particular section. And then apart from this, we can also explicitly give certain one important topic, that is fundamental rights. Fundamental rights, when you analyze a question, the first question is, what do you understand by So fundamental rights, the first question that was asked in 2014 was, what do you understand by the concept freedom of speech and expression? Does it cover hate speech also? Why do the films in India stand on slightly different plane from other forms of expression discussed? So the freedom of speech and expression was in news, and that is one of the reasons why this was being asked. So when any particular issue is in news, you need to have the basic idea what issue is all about and what is the issue, that is what is actually causing that particular issue. So is it a particular significant provision or is it a particular rule that you need to be aware about? And then again we look into the second question, discuss the section 66A of IT Act with reference to the alleged violation of the Article 19 of the Indian Constitution. So that is, again it was with respect to a special provision that was affecting the Article 19. So that is why this was being used, because it was the fundamental rights was being affected. So that is why it is explicitly given. As I have already said, the recent Supreme Court judgment saying that the right to privacy is a fundamental right is another potential question that can come with respect to the fundamental rights also. So when you analyze the polity questions that have been asked over from the 2013 to 2016, you can say that one has to be aware about the conventional area, because for instance it is saying what do you mean by the term quasi-judicial bodies. Now that is the basic question. To summarize or to brief, when you approach polity from the mains perspective, one has to be aware about the syllabus first and the various things, and you need to look into the each topic. That is, if it is in the Indian constitution, the significant provisions, if it is in the quasi judicial body, the various quasi judicial bodies that are in news. So you need to have the basics about what exactly that particular topic is all about. Is there any issue that is is there any issue that is associated with that particular topic, and then look into that topic and implications, or you can say what is the implications, what is the pros as well as cons of this particular issue has to be looked into. So these are the things that you have to be aware about while preparing for the Indian polity from the mains perspective. That's it. Thank you.